Deadly conduct charges. What does it even mean to be charged with deadly conduct? Hi, I'm Jeff Hampton with the Hampton Law Firm. I want to welcome you to our YouTube channel. Today I want to talk to you about the crime of deadly conduct. Now, there's a lot of misunderstanding about what this crime actually is, what has to be proven by the state of Texas. And so I want to not only explain it to you, but I want to possibly show you a way that your case may be able to be dismissed, depending on your circumstances. And by the way, if you wait around till the end of this video, I'll also provide you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, let's talk about this for a minute. Now listen, deadly conduct sounds horrible, right? I mean, it says deadly. So obviously when you're charged with a deadly conduct, it sounds horrible, but there's a lot of confusion. Most people that are charged with, say, an assault or something along those lines, they know what that means. They know that someone was hurt. But in this situation, it's a little bit different. You can actually be charged with this crime and no one was ever hurt at all, literally no injuries. So let's talk about what this means. What constitutes deadly conduct under Texas criminal law? Under Texas Penal Code Section 22.05, the prosecutor must prove the following elements of the crime of deadly conduct beyond a reasonable doubt. They must prove that you, and this is key, recklessly, and I'll go back to this in a minute, that you recklessly engaged in conduct that placed another person in imminent danger of serious bodily injury. That's one way. Or you knowingly, now we're talking knowingly, a different type of criminal intent here, knowingly discharged a firearm at or in the direction of one or more individuals or a habitation, building, or vehicle, and is reckless as to whether the habitation, building, or vehicle is occupied. Now, let's go back to the first definition of deadly conduct. Notice the very first definition required reckless behavior. What does it mean to be reckless? What does the law mean? When you look at Texas criminal law and it says recklessness, what is that? Let me give you a definition of it. Recklessness is defined as one who is aware of the circumstances but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. Now I'm going to go into some examples of this here in a minute to better help you understand what we mean on that. But now the next part is, we talked about it. Notice the definition was that you recklessly engaged in conduct that placed another person in of imminent danger of serious bodily injury. Let's talk about that. What does it mean, serious bodily injury? Let's give you a definition under Texas criminal law about serious bodily injury. Serious bodily injury is defined as a permanent loss or protracted loss of use of a bodily member or organ. So in other words, someone that's placed in fear by some reckless behavior on your part, they're placed in fear of being crippled, losing their eyesight, losing their hearing, something major, not something minor. We're talking about something very substantial when you talk about serious bodily injury. Now, here's the thing. Under Texas deadly conduct law, there is a presumption of recklessness and danger if the accused knowingly pointed a firearm at or in the direction of another person, regardless of whether the accused believed the gun to be loaded or not. So if you point the gun at someone, whether you knew it was loaded or not, if that action ended up being reckless and placing someone in fear of serious bodily injury, that there's a presumption of reckless behavior in that situation, okay? Now, let's talk about what is the difference, because here's the thing. Deadly conduct can be charged as a misdemeanor or a felony crime, okay? Two very different types of consequences and punishment ranges. So under a misdemeanor, most cases, when you look at maybe an attempted aggravated assault, some attempted action where no one was hurt, that's where you end up talking about a possible deadly conduct. This means under a misdemeanor deadly conduct that your conduct has risen to a level of placing a person in fear of serious bodily injury. In effect, what this means is that you could face these charges. Let's say you're moving a firearm around in public. You're just literally grabbing the firearm and moving it around like this, or a knife, or you're shaking it around and someone's freaking out. panicking as to whether or not they see this and they believe they are being placed in fear of serious bodily injury. Well, under Texas law, if you're charged with that, I'm not saying you're guilty of it, but if an officer hears those facts, there's a good chance they may charge you with deadly conduct. That would be a Class A misdemeanor, punishable by up to 1 year in the county jail and up to a $4,000 fine. Okay, we've defined misdemeanor deadly conduct. What about felony deadly conduct? Well, here's an example of this. What if you have a gun and you're kind of pulling it around, you're waving it around, or maybe you grab it and you're saying certain things, or someone is saying something to someone else that could be taken as threatening, and then the firearm goes off. Let's say it's discharged in a home, maybe a vehicle, a school, some other dwelling where other people are at. In that situation, those actions could have caused serious bodily injury or death if someone had been shot. So whether you were aware that there was anyone in the dwelling or vehicle at the time, that is another issue, because being aware of whether or not someone that could have been placed in that fear, right, can affect whether or not it'll be charged as a felony deadly conduct charge. But here's the thing, if you acted recklessly because you knew the danger of firing the weapon, if you knew that someone was in that house or someone was in that vehicle and those actions are deemed to be reckless, you could be facing a third-degree felony deadly conduct charge, which is punishable by a minimum of 2 up to 10 years in prison and up to a $10,000 fine. Now, I want to spend a few moments talking about possible defenses to the crime of deadly conduct, okay? Let's talk about some ways to attack this. And here's the thing. There are some very tried and true defenses on this. Anytime you start talking about you've got to have been reckless, or under the misdemeanor definition, or you had to have acted knowingly in some regard on the felony definition, now you start looking at the issue of criminal intent. The number one criminal defense we would look at right out of the gate is, did you have the criminal intent for the crime? Now, as we discussed previously, the state of Texas will be required to prove beyond a reasonable doubt that you recklessly engaged in conduct that placed another person in imminent danger of serious bodily injury, okay? So there's recklessness right there. Then they must show on the other definition for a felony that you knowingly discharged a firearm at or in the direction of other people or a place where other people might be, all right? So now let's talk about that. Let's talk about the element of recklessness. What if the firing of the gun was accidental? What if it wasn't reckless at all, but maybe it was negligent? What if something happened by pure mistake or accident? Guns can falter. They can go off unexpectedly. For example, we represented someone where they were cleaning their gun. Now, I'm not saying this was smart, but they were cleaning their gun in their apartment, and the gun accidentally discharged. Well, the people below freaked out. I mean, they absolutely panicked, said this guy was acting recklessly. I can't believe he did what he did. He ended up being charged with a deadly conduct, but we were able to show that it wasn't even something he was necessarily doing. It wasn't like he was playing around, acting like he was going to shoot, and the gun went off. He was actually cleaning the weapon with no expectation, and it was a negligent act, not necessarily reckless. So the point is, in that situation, we were able to negotiate a favorable result for our client. We had another case where a client was she had a weapon in her hand. She was falling to the ground, which caused an accidental discharge of the gun. Her falling to the ground had nothing to do with her. She had been pushed down to the ground, and it caused the gun to go off. In that situation, we argued that the firing of the gun was unintentional. So remember, that's the second part of it. If the gun actually goes off, the first example, and I want to break this down because I don't know if I did a good enough job of this at the very beginning. For a misdemeanor deadly conduct, we're talking about recklessly using some type of weapon, waving it around or doing something in a reckless way that causes someone that fear, okay? If the felony deadly conduct, we're talking about the gun going off, okay? If that gun goes off, it had to have been knowingly fired in the direction of someone else or a location where someone else would be, where they would be, placed in fear, okay? Fear of serious bodily injury or death. Now, in that situation that I'm talking about here, this person fell down and the gun went off. She wasn't acting intentionally. She wasn't even trying to shoot the gun. And we were able to show that there was no criminal intent here, all right? So it doesn't matter if the gun goes off or if there's a gun involved. If criminal intent is not established, your case should be dismissed. Now, another example of the defense of criminal intent is when a weapon was discharged, but it was not knowingly fired in the direction of an individual. Now, what if that action was not knowing? I'm going to give you an example. We represented someone who had been arrested or initially investigated for the crime of deadly conduct for taking target practice at a remote area near grain silos. Now, he had gone out there before and it looked like it was completely abandoned, no one else out there. So he was just shooting, taking target practice with his gun. Now, look, is that a good idea? Probably not. Probably should have gone to a gun range or something along those lines. But he had no idea, no expectation that there would be anyone in that direction that would be placed in fear. So he did not, our argument was, he did not act knowingly. So that's a good example of when that type of case could be dismissed for lack of criminal intent. Now, let's talk about defense number 2, lack of imminent danger of serious bodily injury. Now, for the misdemeanor deadly conduct case, we talked about there is the element of proving reckless activity, recklessly engaging in conduct that placed another person in what? Imminent, here's what it's called, placing someone in imminent danger of serious bodily injury. What if your conduct may have been arguably reckless, but a reasonable person under the circumstances would not have been in fear of imminent serious bodily injury? This is a critical point because the prosecutor must prove both the criminal intent and the imminent danger of serious bodily injury based upon the statute, okay? If they're not able to prove that beyond a reasonable doubt, your case should be thrown out. Now that leads me to the next point as we get closer to wrapping up this video, is what if you are facing a felony deadly conduct case? Well, this is critical. If one of these defenses we've mentioned, and there are many others as well that could apply, but if one of these defenses applies to your situation, it is critical that you hire an attorney, an experienced criminal lawyer that has a proven track record of making presentations to the grand jury to try to address these issues. Now, if facing a felony charge is a big deal, okay? But every felony in Texas, including a deadly conduct charge, must be presented to a grand jury for indictment. And essentially, the grand jury is kind of like a water filter. They are supposed to kick bad cases out and let good cases, good for the state, or cases where there's probable cause, to continue forward in the court system. The problem is if your attorney does not gather this evidence and provide an evidence packet for presentation, then the grand jury only hears one side of the story and does not get a chance to hear your side of the story as to what actually happened through your attorney. So the grand jury actually has a couple of choices. They can approve the case as a felony. That's number one. Number two, they can lower the case down to a lesser misdemeanor charge, say from a felony deadly conduct down to something lower, a misdemeanor type offense, or they can do what's called no-bill the case. And a no-bill is essentially a complete dismissal of the charges so that you will be able to get this entire arrest and charge completely expunged from your criminal record. So listen, it's very serious. Whether you're facing a misdemeanor or a felony deadly conduct charge, nobody wants this on their permanent criminal record. It makes you look like you're a violent person, and it'll affect your future. So I want to give you the opportunity, if you or a loved one are facing a deadly conduct charge in the North Texas area, maybe out of Fort Worth or the Dallas area, don't hesitate to contact the Hampton law firm. We'd be happy to give you a free consultation. We'll give you a free case analysis and walk you through some of these points so that you're protected. You have an opportunity to get this put behind you and move forward with your life. Now, I promised you if you waited around to the end of this video, I would also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All you have to do is click the link below, and I'll be happy to email it right over to you. Listen, I want to thank you for joining us here today. If you liked what you heard, subscribe to our YouTube channel, like this video, and I'll send you more great content just like this. Thanks again for joining us. We'll see you next time.